This is the time set for oral argument in 1 CACV 160578, time set for the oral argument in Bowe versus Vogel. Counsel, each side will have 20 minutes for their argument. Appellant may reserve a portion of that time for rebuttal if you choose to do that. Please keep track of your time using the podium clock. Counsel, we have read and conferenced these cases this morning. Please keep that in mind as you present your arguments to us this morning. These proceedings are being recorded. They will be posted to YouTube. So before you begin your argument, please state your name and the parties that you represent. With that, we will start with counsel for the appellant, Ms. Gilbride. Oh, Ms. Hallier.
Ms. Hallier.
I'm sorry, go ahead.
Good morning. Angela Hallier for appellant Julie Bowe. I would like to reserve 10 minutes of my time for rebuttal today, of course, assuming that your questions don't take me further. I am very interested in what your questions are today because we believe the record is very clear, our briefs are very clear, and the law is very clear. So I will generally go through the 4 issues and hopefully answer all the questions you have. First of all, on the issue of child support, there is no question that the court abused its discretion in not performing the lifestyle analysis required by Nash. Nash specifically says, in deciding child support after divorce where there's been an affluent household, the Superior Court must consider the expense of allowing children who have enjoyed such benefits to continue to receive them after dissolution. And Father does not contest in his answering brief that the court failed to conduct such an analysis. In Nash, this court found the trial court was in error in not considering entertainment, travel, housing expenses of the family prior to divorce. And this comes from our income shares model, that child support is to approximate the lifestyle the children would have had if the parents lived together. And as the court said in Nash, even if someone doesn't prove every penny of the amount of deviation, if the court finds deviation is appropriate, they must do a lifestyle analysis. And in this case, the record is replete with information about...
There was a deviation here, though.
There was.
So the court wasn't operating under the assumption that it could not deviate, and there was, in fact, an upward deviation. Why doesn't that put us more into the land of abuse of discretion, particularly given the court's comments that the previous lifestyle seemed to be unsustainable? Right.
So the court did deviate, but it didn't conduct the lifestyle analysis necessary. Nowhere is there anything about the lifestyle. And even though the court said the lifestyle that was created for the children maybe was untenable during the marriage or untenable after, because it is true, mother tried to keep that lifestyle in place. She presented evidence to the court that the allocation that she was spending on the children post-decree was $30,000 a month roughly, but she didn't ask for that. She asked for...
But counsel, if the court didn't conduct that analysis, on what basis was there an upward deviation then?
Because her ruling, the judge's ruling specifically just said, father could afford the counseling expenses more than mother. That relieved mother of only $120 of an obligation. The court said father could afford the expense of tuition better than mother, which again, that relieved her of 30-some% of the obligation, and that father could afford the one-time college prep course. Finding that father could afford certain expenses is not the same as what's mandated when you look at what are the direct and indirect expenses a child incurs in a household and what should the lifestyle be afterwards. Because remember, this is $1,200 a month for 2 children on a record that shows father's average income was $200,000 a month in the years prior to the divorce.
But the income isn't, at this point, following the divorce, there's now, she's receiving payment, spousal maintenance. His income is not that. Why does that necessarily translate to there has to be a higher standard of living now for the kids than what's now available to mother through what she's received through the settlement?
Well, the court didn't even make that determination. The court never got there. The court didn't analyze. There was testimony by father himself about during the marriage, taking the kids to sporting events, teaching them to ski, taking them on vacations. The court didn't account for any of that, as Nash says you have to. And I'm not sure I got your question about now that there's not that income or something.
Well, you're only pitching this is now father's income, but he has to give some of that to mother.
Right. He gets a tax write-off, $25,000 a month. She has to pay taxes on that. That's the income. And his demonstrative or the demonstrated income, whether you take a 2-year, a 3-year, or 4-year average prior to trial, was $200,000 a month. And the court imputed or used a lesser income for him than he'd ever made at any time in recent history, less than he admitted on the stand to the judge when she asked him what he could make. The judge asked him, what do you think I should use? He said, well, maybe 1 million, 2 million some years, 3 million in a good year. She used less than all those numbers. So the combination of the two things, by erring in what his income was and absolutely not doing a lifestyle analysis. I mean, the detail, and this court, when it issued its rulings in Nash, was in accord with many, many courts around the country that we've cited to. All of them talk about, and maybe it's best stated in.
Did they talk in Nash? Was there a discussion that the parties' pre-divorce lifestyle is not sustainable?
There wasn't an issue of sustainability. In that case, father argued for more modest conditions, and this court recognized that the court can give weight if a parent argues for more modest conditions. There was no such argument in this case. There was no testimony by father whatsoever that the children continuing to have and be able to have sporting events with mom, having friends over, having parties at mom's house, going to vacations was inappropriate.
But at the there certainly was an argument that the level that was requested was inappropriate.
No. There was an argument that the level she had been spending was inappropriate, not what she asked for. Because remember, again, we had all the years of their marriage, the 3 years prior to the divorce even being filed, were meticulously outlined in exhibits to see exactly what they were spending. Mother testified that she tried to keep that lifestyle for the children afterwards, and she estimated that, including direct and indirect expenses, at $30,000 a month. She didn't ask for that. She asked for $12,000 for 2 children and $10,000 when the older one matriculated out of high school. There was no analysis of that, nor objection to that $10,000 or $12,000.
Let me go back to, I realize these are probably two separate issues, but you raised the issue of the amount of income assigned to father, attributed to father. Why was that an abuse of discretion given testimony relating to the uneven nature of the unpredictability of a future salary?
Well, it would have been most appropriate to average it, because if the divorce trial would have happened in 2014, his income was $292,000 a month. The court many times in its rulings recognized the varying nature of the income over time because of the history, but it based its ruling on not even the lowest amount he'd made in the last 4 years. And the testimony by the company president was that in 2016, as of the time of trial, mid-April, the company was up almost 30% from the year before. All the other experts testified that the value of the industry is trending upwards. And the only written direction we have on that is a case called Levine. It's a memorandum decision. And it, said, yes, the Court of Appeals said, yes, trial court, when you have varying degrees of income, you can average the last 5 years.
But it doesn't say you can't consider other factors. If there is any suggestion that there's a possibility that the income could be less in the future, it's necessarily an abuse of discretion if you don't just average the previous 5 years' income.
The record was devoid of any evidence it could be less in the future, even by father's admission to the judge when the judge specifically questioned him. He never claimed he would make less than his lowest year in the last 4 years. And in fact, he admitted to the judge he could make 1, maybe 2, in a good year 3. Let me move on real quick. to the business valuation with regard to the lack of control. The fallacy is that father is not a minority shareholder. He does not lack control. No one can do anything without him. He is the manager. He cannot be removed as the manager without himself voting for it. He is a majority shareholder and has certain rights under the operating agreement, and he can veto anything that takes a supermajority. So no one else has that control. He has the ultimate control. And with regard to marketability,
ultimate control, there's still a supermajority is required for some pretty significant decisions, isn't that correct?
Not really that many decisions. There's not that many. One of them is the amount of the distributions. The operating agreement says there will be. Nobody can make that decision without him agreeing. So perhaps the word ultimate was too much, but no one can do anything without him saying okay.
So I would certainly agree that he does have significant control, but you would agree that it's a different scenario than one in which he's 100% owner of the company and he doesn't need anyone's vote to do anything.
That's correct, but you don't need that under Schickner, and you don't need that under Bryson.
You just have to have some control. If it's not complete control, why wouldn't that again push us into the land of a discretionary call by the court that you could certainly look at it and say that he has more control than other members of the business, but he doesn't have total control, and so there's arguably a need for at least some type of discount. You can argue over how much that discount could be, but I'm hard-pressed to say there's not an entitlement to have it be discounted at least at some level.
I don't necessarily agree. I think that Schickner was clear that the discount for the minority is appropriate, not the amount. It's the amount of the discount goes on a case-by-case basis. The issue of whether you have enough control to have a discount applied or not is really the issue. And Schickner said when a minority shareholder has no ability to control money or the day-to-day corporate operations, then it's appropriate, but he's not a minority shareholder. Then
does that factor in the supermajority requirement? If you didn't have that requirement, I would agree that there's no concern whatsoever. But there does seem to be at least something there in terms of the requirement that there be a supermajority for some decisions.
Just for some. And then who has the power then? He has the power.
Counsel, he's the power to deny if he needs a supermajority. If he's not the supermajority, he has to have cooperation from someone.
Right, or nothing will happen. So in real life, in the real world where people in a company want their distributions, they either have to go with what Mr. Vogel says or they get nothing because he stops anything else from happening.
That's true for him as well. If he wants a particular distribution, that's what he wants. If the others don't go along with that, then he can't exercise his will on that.
And I guess the proof is in the pudding because of the huge distributions that have always been made. I mean, the truth is everybody wants their money out, and he has the power to stop those. Unless you have something else, I'm going to save my 7 minutes, 20 seconds. Did you have something else on that? Because I'll stay.
Thank you, counsel.
Good morning. May it please the Court, my name is Mitchell Reichman. I am appearing this morning with my partner, Kathy Sandweiss, who worked with me to prepare Father's presentation today. We represent the father, Greg Vogel, the appellant. While there are many unique issues in this complicated dissolution proceeding, one I think is worth noting is the remarkable engagement of our trial court judge, Ronnie Corbin Steiner. She managed the case in pretrial stages very hands-on and very efficiently. She conducted 4 pretrial conferences. She listened to a 3-day trial. She looked at hundreds of exhibits. She heard the testimony from a mutually engaged expert, Linton Kotzen, who is very well recognized in the courts. Another expert, Charles Wilhoit, also of the highest caliber. Don Miner, who was a senior partner of Fenimore Craig, who was involved in drafting the LAO operating agreement at issue, and Mother's experts. and rendered a 110-page, well-reasoned decision that's supported by substantial evidence and is entitled
Could you
to be
address the
upheld.
first point that counsel made relating to whether there was a lifestyle analysis that was done,
Certainly.
and whether that's required?
Absolutely. There was a lifestyle analysis on all of the categories of the various aspects of the lifestyle that were presented. Judge Corbin-Steiner specifically examined and commented upon claims mother made for vacation expenses, groceries, housing, utilities, transportation, childcare, and an expense for even maintaining horses and having parties for the children. She specifically recognized the cost of private school, of uniforms, of counseling, all as part of this lifestyle analysis. There's no direction in the case in Nash that says specifically what it means to do a lifestyle analysis. And what is important here to recognize is that what does the trial court judge do when they find the lifestyle is artificial? This is their specific findings saying this lifestyle before the parties separated and while they were separated was not based upon very substantial earnings. It was a fiction. It's artificial. From 2009, when the real estate market crashed and there were no distributions, and Ms. Hallier isn't correct about that, there were years when there were no distributions, including 2011, which is pretty recent, father couldn't control the spending. That's clear in the record. They had a free and clear house they built in Flagstaff for $4 million. They borrowed $1.6 million on a line of credit from the house which she spent to support the artificial lifestyle. She claimed she lost a $100,000 piece of jewelry. She didn't tell her assistant about it. She didn't tell father about it. She took that $100,000. She put it surreptitiously into accounts no one ever knew about. She took money out of the boy's trust. She misappropriated it. She misappropriated money from Thora Vogel, Mr. Vogel's mother's trust. She misappropriated money from Thora Vogel. All of that is supported by the record. All of that is in Judge Corbin-Steiner's findings that support her conclusion that this is an artificial lifestyle. It is unsustainable. And beyond that, she recognized, and father testified, and Mr. Rosner testified, he was even brought in, he tried to control the spending. These were not two people on a path outspending anything that ever came in and trying to grab more. This was mother, and he couldn't control it. He tried to control how much she could write for a check. He didn't even know about the money she had taken and spent. And so the idea that you can create an artificial lifestyle and then come into court and say to the judge, well, look at what we've spent, and you have to duplicate it, is just not the law. And what Judge Corbin-Steiner did was an exercise of her authority. She has the discretion clearly under Nash to decide what an appropriate amount for child support is. And she did that. She also recognized properly that mother had the burden of proving that the needs of the children required a child support amount that was an upward deviation. And she also had the burden of proving that the amount that was going to be given to her for child support was in the children's best interest. Judge Corbin-Steiner reviewed all of the spending that she rejected as unnecessary, unsupportable, inappropriate, including buying a $2.3 million house on Exeter Boulevard when she moved out of the Paradise Valley house. She rejected all of those expenses, and she said, these are not in the best interest of the children. I'm not going to consider any of those because you haven't met your burden. But she focused on very specific categories of expenses that she said, yes, this is for the children, and I will have father pay for it, and this is a deviation, and these are in the best interest of the children. She recognized them specifically, the private school, the counseling, uniforms, some tutoring for Johnny, and she ordered him to pay those until she found there is a deviation. The best interests of the children were served by that.
But I'm reading mother's argument as the court is improperly focusing on wasteful spending, on mother's expenditures, as opposed to just an analysis of this is what an appropriate lifestyle for the children would be and can be afforded. Mother's not asking for the exact same level as was being spent before, but mother's suggesting at a minimum the court should do that type of analysis and just say this is what the parties can afford, as opposed to just focusing on mother has wasted money in the past.
Respectfully, Judge, I don't think that Judge Corbin-Steiner did that. She recognized that father has an obligation of spousal maintenance of $25,000 a month. So with child support and spousal maintenance, she's getting $26,200 a month. The decision recognizes that's enough. That's sufficient. Let me move to the question of the valuation of the business. I think this is presenting you a really good opportunity to clarify some of the law on this. We believe the trial court acted within its discretion in valuing the business. There are really two aspects to that. One is was it appropriate to adopt a value that included a discount for lack of control? And the other is whether it was appropriate to include a discount for lack of marketability. The language in Schickner is unfortunate when it talks about a minority share discount and identifies the factors to consider for a trial court making that discount and includes lack of marketability. It's clearer in Bryson, which is a little clarification there. There's two separate discounts. One is for lack of control. One is for lack of marketability. There is no minority share discount. It's not a term of art in the business valuation context. And
but
really,
you would agree there's differing levels of control that would warrant perhaps a greater discount. If someone has a 1/5 share, it's obviously different than someone with a 50% share.
it depends on what they can do with it, and here's where you need to have the analysis. This is why all the cases that discuss these discounts talk about the fact that it's decided on a case-by-case basis. And that's because we're dealing with ownership interests in private-held companies that are created by agreements. And so you have to look to the terms of the agreement and the specific ownership interest that you're trying to value to decide what are the attributes of control that this ownership interest has under the terms of these documents. This case is a perfect example. If you knew nothing other than the fact that the community owned 58.32% of LAO, you would say, well, that must mean no minority share discount. But then you see it requires a supermajority. Then you look at the attributes of control analysis Mr. Kotzen provided, 10 different categories. You can't compel a distribution. You can't take money out unilaterally. That's what matters to you, unilaterally. What is the holder of this interest able to do unilaterally? That's what gives this interest value, a control premium in the lexicon of the business valuation experts.
So you would agree that it would be a lower discount for someone with a 60% interest where it takes 70% for a supermajority, as opposed to someone with a 10% share of the company. Certainly, there's less need there's a need to persuade fewer people to get you to do something, and so arguably the control discount should be less if you control 60% and it requires a 70% supermajority.
It seems on its surface that makes sense, but it really depends on what they can do unilaterally. Sure, you could say, because if he had, this is like...
Whatever you can do, he can do it easier than somebody with a 30%.
Yes, the discount that applied here in the findings aren't that he had no influence. That's not, and we never argued that. He certainly has some influence. He owns a greater percentage than any of the other owners. But under the terms of the agreement that defines what his rights are, he can't replace management. He can't get money out of the company. He can't liquidate a single asset the company owns. He can't sell the company. So he's locked in. By himself, he can't take out a dime. And when you read Mr. Wilhoit's testimony, when you see the attributes of control analysis by Linton Kotzen, there's substantial evidence to support there being a discount, and the magnitude of the discount is well within the discretion of the court. So I think that the record is more than complete to affirm the court's decision on the value of the business. One thing I want to point out...
If I could ask, the marketability discount was
Yes.
coupled with the control discount. It seems to me that there's at least some overlap between marketability and control. I realize there could be entirely different factors for marketability, but in this case, are those factors completely separate? I mean, a share...
They're separate because, as the Court of Appeals stated in Toff, and I'll read it because it's important, in contrast to a minority discount or discount for lack of control, a marketability discount addresses the degree of liquidity of the interest. Such discount compensates for lack of a recognized market for a particular stock, lack of ready marketability, or restrictive provisions affecting ownership rights or limiting sale. That's really the basis for the separate discount here.
Ownership rights, that
Right.
seems to be dovetail a little bit with control.
I think you're right. It does to some extent. There isn't a bright line between the two, but they're clearly different, and the empirical data that the business valuation experts use to decide the proper magnitude is different data, is clearly different data.
And how significant is the factor that there doesn't seem to be any contemplated sale?
Well, I don't think the record supports that. I specifically asked Father, do you agree with Mother's proposed finding that you do not intend to sell the business? And he said no. And I can read it to you from the record, but it's in Reporter's Transcript A3, his testimony on pages 295 to 297, and he describes his plan to try to create stream of reliable revenue for the business, which revenues were primarily generated from transactions, so it's very volatile, so the business would be more attractive to sell because the plan is to sell it. There's no finding here that there was no intention to sell, only no present intention to sell because 2015 was a bad year, and so you don't go looking to sell the business right after a bad year. There's another important component that you have led me to on this, and this is Mother made a more cogent presentation in her reply brief on this issue. She claimed that based upon the evidence that the court should conclude as a matter of law that father's interest cannot be sold apart from the whole, and therefore a minority share discount, as she describes it, should not apply, or lack of marketability, because he'll never recognize that discount on sale. There's an implicit assumption here that is refuted by the record that defeats this argument entirely and causes me to suggest you should reject it. And that is the assumption that he'll receive a pro rata distribution from a sale. When you look at the testimony of Don Miner, and this is the basis for some of Judge Corbin-Steiner's findings, particularly same day, Reporter's Transcript 3, Day 3, page 63, I think it's important to read it to you because it points out how well supported the judge's decision on discount for lack of marketability was to this point in Mother's reply brief. It says, what we're talking about is that from the perspective of marketability, if the company were to be sold as a whole, while that is a possibility, it would be very difficult to accomplish. And that is because you'd have to have the provisions satisfied where all of the members have to consent because they would still be in effect. So what the judge is talking about is, it's an article, it's in Section 7 of the LAO Operating Agreement. The company can't be sold unless everyone agrees. And as Mr. Miner points out now, if any one member refused, it couldn't happen. And there's absolutely no assurance that all of the members would consent. Or if they did, whether they would be willing to accept a pro rata payout of their percentage interest in the company. The smaller members might say, and I've seen this happen before, look, this is my livelihood you are talking about. I don't want to accept this small amount, meaning their pro rata percentage, to have the company be gone, or this amount to have the company gone. I'm not consenting. Their consent is based on a sole, absolute, unfettered discretion. It's speculative at best to say that could be accomplished. And so the idea that just because it's more likely that his father's interest is sold as part of the whole compels you to conclude that he's going to experience no minority share discount is defeated by this statement by Mr. Miner. And the court specifically cited this portion of his testimony in its ruling and said the court agreed with the analysis. And when you look at the judge's ruling specifically on this part of it, and this points to fairness. I think one of the things that Judge Corbin-Steiner should be congratulated for is she really thought about what a fair conclusion would be. She understood that is her overriding obligation. It says, father is purchasing mother's interest now tax-free to her, right, $1,760,000. It is unknown whether father will realize cash in exchange for that interest. It is unknown if father will never get, little typo, should be ever get, the value that mother will receive if this court elects to apply the fair value standard. She recognized, based on the evidence presented to her, that there's a chance father's locked in, that there's a chance he's never going to get the $3.5 million equivalent tax-free that he would have to have for this to be fair to him. And for all those reasons, I think the court there's more than enough substantial evidence for the court to uphold the decision on the value. I will also mention that Judge Corbin-Steiner was careful to adopt all the findings of Mr. Wilhoit, all the findings of Mr. Kotzen that did not conflict with the findings of Mr. Wilhoit for the valuation at 2014. So all of those findings are incorporated in her decision to support it. I don't know that I really have anything more to say with respect to the child support award. I would mention, though, however, that one of the things that allowed them to live the artificially high lifestyle were the tax carry forwards. There's a subtle point there. Because of all the losses they had incurred and all the real estate deals that they were in when the market crashed, they had these huge tax loss carry forwards. Father testified there were millions of dollars. So what that created once he started to make money again after the market started to recover is he's getting income, a lot of income, and he is sheltering that income by taking advantage of the tax loss carry forwards. So the cash flow is artificially high because he's not paying income tax on his income. That's not true anymore. That got used up, but that was one of the ways that they're able to support an artificially high lifestyle during the 4 to 5 years that the judge was examining, and she recognized that in her decision. I would also like to mention something on the 2014 commissions, unless you're not interested in hearing it.
Go ahead.
Okay, because I do have a couple of minutes. I think the important thing about the 2014 commissions is, number one, the date of service was January 22nd. So, 340 days of the year, Mr. Vogel, father, was earning money as his separate property.
I mean, if you could address the failure to cooperate, there was going to be cooperation. Instead, it's here, this is what it is, here's my testimony.
Yes. There was cooperation, but not what Mr. Fleischman was asking for, but there's a good reason why. There's no value to a listing. This is raw land. LAO and father have had some of these listings for 10 years. If you look at the 2014 commission schedule.
What was the information that was being requested from him that he did not provide?
He wanted Mr. Vogel to go through all of his emails, all of his records, any information that he had, credit cards, any information he had to show his actual efforts with respect to every transaction that closed in 2014, so he could somehow analyze how much time had been spent before January 22nd and how much time had been spent after on all the commissions he earned. That's what he asked for.
Well, and what was unreasonable, I thought the argument was that the listing itself doesn't establish a right to a commission, but the work being done on it would be something that, and if that was done before the petition, then that's community property.
That is the argument.
So why don't those records that were requested go to that issue?
Because we took a big picture view to try to establish, and what happened established that it was unnecessary to do that analysis. If you look at the 2014 commission schedule, which was Trial Exhibit 152, which was Mother's Exhibit, Mother allowed the court and asked the court to admit, and the court did admit, an exhibit that included Father's entire presentation on that year before he testified. You can isolate specific transactions that were absolutely sole and separate. The largest one was an investment group that came to him with a very large gain from a sale of other real estate that they wanted to roll into property in a 1031 exchange. Said, we need to spend these millions of dollars. Please help us buy property with it. That was like in August. There was like not a chance. It just started. So that was isolated out. There were a couple of other really large transactions that were almost fully 100% based on separate interests, separate property efforts. If you took that out of Mother's analysis, then and just looked at those, her analysis failed. Right? She argued in her analysis that there was a little over $2 million between commissions and distributions that Father received in 2014, and she has the burden of proving that what he received after the date of service is anything other than sole and separate, but she decided to lump it all together in her analysis. Once we carve out, and I went through this in some detail in our answering brief, once you carve out these transactions that there were no question were separate, and you disregard the rest and you pretend they're community. She got overpaid out of part, and you consider what he gave her during that year from his earnings. She got overpaid by like $300,000. It wasn't a close question. So why would we go through tens, maybe hundreds of hours of effort to put together this record of all the transactions when you can just identify the few that defeat the entire analysis? So that's what our focus was. And we told Fleischman that, we gave him that. I wrote him and I said, this is a waste of time and effort and here's why. And so that's why we didn't go to the effort. And, the judge's decision was fair in terms of allowing him to testify based on the fact that the exhibit was already in. Last thing I'd like to mention is on the fees. I'm almost out of time. Unreasonable behavior caused unreasonable activity in this litigation. That's what Judge Corbin-Steiner found. She said the record, the docket was replete. Remember, she took over this case like in the fall of 2015. The docket is replete with unreasonable pleadings based on unreasonable behaviors. And it was on both sides. And I think that she's right. And both sides had a lot of money and spent a lot of money on fees, and she recognized that. And I think that it was an appropriate exercise of her discretion to decide there would be no more. Thank you.
Thank you, counsel.
Yes, briefly first, there's nothing in the record about these tax benefits that Mr. Reichman was just talking about, nor is there anything in the record that says Mr. Fleischman was looking for every single thing father had to do the 2014 commission analysis. He was looking for calendars, phones, and emails. The court found that father could have given those to him, but chose not to because he said it was too much work. I want to talk about...
But do you disagree with the assertion that the really big items were clearly separate?
No, because it's all about when did those hours work? When did you create the relationship? When did you get the listing? How much did you work to get the contract? Father's chart, self-serving chart that the court let him testify to merely said either community, sole and separate, or 50-50. The parties charged someone else with doing the discovery. They promised to give him what they wanted. Father didn't give him what he wanted. The court found that failure did not allow then that master to do his job, but then father was rewarded because the court entered its orders on the commissions based on that testimony.
Father did have an opportunity to cross-examine him during a deposition. I mean,
there was no reason to. His deposition was 2 weeks after he produced that sheet, and the whole entire issue had been delegated by contract to someone else. The parties had delegated that entire issue outside the court to someone else to do all the fact-finding. With regard to the child support, this whole thing about this overspending, let's remember, this is a family with the kind of means that most of us will never know. This isn't, does dad make $20,000 a month? This is, in the years prior to the divorce, he made $154,000 one month, $154,000 a month for 2012, $252,000 a month in 13, $292,000 a month the first year of the divorce. And I think the court's error is evident in its ruling on pages 73 and 74, because it talks about what mother said the expenses were that had been spent on the children prior to the divorce being filed. And it says she believes because she had done so in the past, she should continue to get to do so. But then it says there's no evidence these expenses, the past ones, are necessary, warranted, or appropriate. And I think that very clearly shows how the judge didn't do the affirmative lifestyle analysis that had to be done. You can't just say, well, too much was spent on those private vacations, so now the kids get none. I guess I'm not making that connection. If you say this was too much was being spent, that's not a sustainable lifestyle. Isn't that essentially saying the same thing, that this is not sustainable? They couldn't have sustained it even if they had remained married. Not on this record, no, not at all. Not when during the divorce father's making $280,000, $90,000 every single month. If too much was spent on the private jets and too much was spent on mansions and too much was spent on ABC, that doesn't mean you don't look at what the children themselves need and follow the income shares analysis, follow the economic studies, follow this court's rulings in Nash. You still have to affirmatively say, this is an analysis. You can't just say, I don't like your analysis, Mom, and you overspent. With regard to the sale, and I want to touch on this issue of the sale of the business, remember that none of these discounts apply whatsoever, as was recognized by the judge, if the thing is sold as a whole. And there was evidence that father turned down opportunities from buyers that he wouldn't sell unless he got the value up to $40 or $50 million. So this whole issue of the sale is fake. There's not going to be a sale of his piece. The owners put this together in such a way it was really hard to sell. So all of the judge's findings on that issue support not applying the marketability.
There will be a sale presumably at some point. Just given the age of given husband's age, it's presumably not going to continue indefinitely. At some point, the interest would have to be sold, and wouldn't a discount apply at that point?
Or he could own it till he dies and keep making money. I mean,
that's right. But assume he lives 15 years. Whatever it is, the value of it. it seems to me you have to at least analyze whether there is a sufficient level of control that he can completely dictate what he's going to do with it, and if it's going to have to be sold at some point in the future, he doesn't have complete control over it. It will not sell for 100% of the value.
Well, it can't sell without him saying, okay. That's very clear. And, I just want to briefly take us back because Schickner and the other cases didn't talk about this specifically. But, way back on Mitchell, the court recognized this same issue when it said, we're dealing with a marital dissolution which does not affect the continuation of a business partnership. A professional practice goes to the spouse licensed to practice it. He's not selling or liquidating, but he's continuing in business. Effectively, it's the case of a silent partner withdrawing from a going business. And if such partner is to receive fair comp, it should be so evaluated. And it's like in Kohler and Goldstein and all the other divorce cases that say, we're not going to make up something that's happening that's not happening. The fact he's staying in business and continuing to reap the benefits is, in essence, why those discounts shouldn't apply. I do want to say, with regard to the fees, we noted in our briefs that father said this would be the trial of all trials to mother in front of their child. And he was able to fund his $1.2 million in attorney's fees, expert fees, child expert fees, et cetera, from his income. Mother had no ability to do that. She walks away having had to liquidate a $700,000 profit-sharing plan. Father leaves with his intact. She walks away with a $300,000 debt. Gutierrez talks about that one of the purposes of the statute is to make sure the person less able to pay can afford this. Mother had to liquidate community assets she should have been awarded to afford it, and the court's award of nearly no fees whatsoever, $8,000 on $1 million, was untenable. We would request quickly that in making your decisions that on the discounts that the court be directed to take away the application of the discounts. There doesn't need to be a new trial, that the court appropriately sanction father for his malfeasance in not going with the special master and just use the calculations we presented, that the fee issue be remanded without a new trial. Mother can't afford that, for her to look at what should be on the record, and that the court hold that father's income should be $200,000 a month, and the court do the appropriate child lifestyle analysis.
Thank you, counsel. I'd like to thank you both for your briefs and your presentation here today. We'll take the matter under advisement, and we will issue a written ruling in due course. The court is now adjourned. Thank you all very much.